All rise. District Court is reconvened.
Please be seated. Ms. Linus, you may proceed.
Thank you. This court, counsel, ladies and gentlemen of the jury. One of the last things that Mr. Perry said was that you are the judges of the facts, and I would ask you to do that because from Mr. Parrish's rendition of the facts and my recollection, I would encourage you to remember your recollection about what the facts were, as there seems to be some dispute about what the actual facts are in this case. I want to hit on one of the things that he stressed repeatedly about how somehow Andrea Farrington was interfering with Mr. Kozak's job. What you heard from Wendy Robbins was that towards the end of April or so, she had Andrea Farrington come to her and was concerned because the defendant had left a note on Andrea's car, and Andrea was concerned because the defendant then knew where she parked and what car she was driving, and this concerned her. Wendy said she took it on herself, not at the request of Andrea Farrington, to go to Cy and Sissime to report it. She also took the time to talk to the defendant to say, leave Andrea alone. Now, if you look at the defendant's Exhibit A, which is the phone records, it will also show, when you heard the testimony of Detective Smith, that they stopped texting each other, Andrea Farrington and the defendant, between April 29th and I believe June 5th. It's consistent that at that time, she didn't want to have more contact with the defendant. The texting stopped between them for quite a period of time. Then at the end of May, Wendy Robbins told you that she received a text when she was at a movie from Andrea saying the defendant was at the Welcome Center, kind of what she should do. And the response, I believe, from Wendy was, tell him to leave. Then around June 2nd or something, Andrea mentioned to her again, he came over to the Welcome Center or something to that effect. And at that time, not at the request of Andrea Farrington, Wendy Robbins was pretty clear on the stand, she decided herself, Wendy did, to go to Cy. Not at the request of Andrea, not because Andrea said, please, don't let him do this, that kind of thing. Wendy told you she felt it was her duty and responsibility as part of her job to do that. There's no evidence at all in the testimony, in the text messages or anything, that in any way Andrea Farrington was trying to interfere with the defendant's job. This is a red herring, trying to suggest that. Then after that, after June 2nd or the beginning of June, it was not until June 9th that Mr. and Sissy Mae talked to the defendant about staying away from Andrea. And it is true, by that time they were texting. But instead of telling Mr. and Sissy Mae that look, we do have a relationship and things like that, the defendant didn't say that. Rather, it was because he was married and he didn't want to admit that he had a relationship with somebody other than his wife, or for whatever reason, he didn't say anything to Mr. and Sissy Mae at that time. He didn't say we're continuing. And at that time, the defendant had a choice. He had many choices. He could have either said to Mr. and Sissy Mae, look, we have a relationship, I don't know what's going on, we've just resumed it again, I'll check and please could you talk to Andrea. Mr. and Sissy Mae was clear though, Andrea Farrington never went to him with any complaints about the defendant. So the suggestion somehow she was trying to get him in trouble at work and trying to do all of this is not supported by any of the evidence in this case. When Mr. and Sissy Mae talked to the defendant on June 9th, by this time they had started up again, and Andrea, having last talked to her friend Wendy about a week before, probably didn't know anything that this conversation was going to occur. But I wanted to talk about that June 9th meeting between Mr. and Sissy Mae and the defendant. If the defendant really suffers from intermittent explosive disorder, why didn't he blow up at Mr. and Sissy Mae? He's getting accused of something he doesn't think he's responsible for. He's getting told he could lose his job if he continues to have contact with Ms. Farrington. He doesn't do that. And go back to what was the discipline about on June 9th? It was about the defendant having pulled out OC spray with juveniles who were bothering him. Again, if this is somebody who has intermittent explosive disorder, he didn't use the OC spray, the pepper spray on these juveniles. He merely showed it as a way of showing his power to get them to leave the mall. This is not somebody who's suffering from this out-of-control intermittent explosive disorder, and when people make him mad, he can't help himself and he becomes violent. On those two occasions, clearly, he was able to control himself the same way he could have controlled himself on June 12th when he was angry. He was not suffering from a mental defect. Now, I want to go through much of what the defendant, or some of the things that the defendant said, and not try to deal with everything. I trust that you heard the evidence. You can make a determination about what you believe happened. When the defendant, though, starts talking about how this was a crime of passion, I do ask you to go back and look at that jury instruction. And I showed it on the screen to you to show you what it says. Words alone are not sufficient, and it has to be of such a nature that a reasonable person would act that way. In addition, it has to be something where the passion is not sudden, violent, and irresistible. It is not sudden, violent, or irresistible if there is an interval of time during which a reasonable person would, under the circumstances, have time to reflect and bring his passion under control and suppress the impulse to kill. Remember, diminished responsibility, no mental defect or anything applies in this. Words alone, however abusive, insulting, cannot be serious provocation. This is not a case of serious provocation. This is not an involuntary manslaughter case. This is a case that is much closer to first-degree murder. When we looked, and I just want to mention something about the charts and how the ages of them, Mr. Parrish left out some of the other witnesses who were there, including Catherine Ogden, Rudy Rodriguez, Kevin Elliott, other people who saw the defendant acting in that way, Jeff Carew, and he wants to draw his circle in narrow to make it look like it's just young people. And he even, I believe, had the defendant's age wrong, and I think he was 22 at the time, now 23. But in a way, we want to make sure that you're not using somehow sympathy because these are just young people. You have to look at the facts. And the unfortunate fact is that a 22-year-old killed a 20-year-old. And that's the truth. And that's a fact. He talked a lot about the texting relationship as well. And I'd suggest that in some ways this is something of a red herring in this case. The number of text messages they had with each other is not really an issue in this case. They had a lot of text messages back February, March, probably into April, but then they stopped for a period of time. They stopped for about 5 weeks or so and only had recently started up again. And you'll see most of those days' texts when you look through the state's exhibits 20A, 20B, the defendant's LL. And on the issue of redaction, you will see it is much easier to read the text between the defendant and Ms. Farrington when you read the redacted version. No good deed goes unpunished, though, and the state will do a mea culpa that we took out other texts, but you can certainly read those and see exactly what the other texts were. But you're not going to find that the other texts that Andrea had with other people are of such a nature that it's going to change anything in this case. They weren't of such a nature, they weren't going and threatening the defendant, they weren't of any nature that it's going to suggest in any way the defendant is not responsible for his actions. So go ahead and read the unredacted version if you want to get a cleaner copy of what was going on between the defendant and Ms. Farrington, and read the non-redacted ones if you want to see all of the text messages. He brought up how there was people who were not texting Andrea as much during that last few days, her mother, her sister, but you actually heard the testimony. The reason those aren't showing up in the text is because they used an app called Kik, and so their text messages don't show up in these records. She could have been texting her sister, her mother a lot, and it's not going to show up there. Then Mr. Parrish talks about how Andrea was leading him on. And he talks somehow about that he was only 20, I think he said 20, he was actually 22, but how somehow Andrea is leading him on. There's nothing to suggest that the defendant didn't understand what his relationship was with Andrea. They did have a relationship. Dr. Hyde described it pretty well. People, especially young people, do text a lot. They're involved in the internet communication. They do have relationships that way. But it doesn't mean in some way that they weren't both parties to this. Keep in mind the defendant was married. He chose to have the relationship with Andrea in this text world. Andrea had a relationship with Connor, but this text relationship she had with the defendant was working at some point in time. Now, when it got a little bit more and he knew where she was parking, that seemed to be when it had stepped over the line in the past with Andrea. I want you to look at the text too, because Mr. Parrish portrays them in a way that is not consistent with some of the texts. He talks about how Andrea was trying to get the defendant to leave his wife, and if you read the text, and I encourage you to do that because I think the texts themselves are much clearer. She was not trying to get him to leave his wife. He was talking about leaving his wife. There was messages back and forth, but Andrea was saying, you do what's right for you. She's not asking him to leave. They both had a choice in this relationship if they were going to stay in it or get out of it. The defendant had as much choice to get out of it as Andrea did. Andrea had every right on June 11th that night, the next morning, to say she didn't want to be in this relationship anymore. She clearly expressed to him on the 12th she wanted to be friends. Could they be friends? And it was her effort to try to get him to be friends that seemed to be actually what set him over the edge when he found out there was somebody else, and that was the reason she didn't want to have the more intimate relationship, but wanted to just be friends. Mr. Parrish puts a lot of stock in the idea that somehow Andrea was interfering with the defendant's work. The facts just don't bear that out. The defendant was talked to by his boss only twice, once about a note being left on the car and that bothering Andrea Farrington, and once because it had been reported he was violating what Mr. Insissime had told him to not do, which was go to the Welcome Center kiosk. And there was no testimony from anyone that Andrea was the cause of that latter one. Now let's talk about Dr. Logan though. And Dr. Logan, Mr. Parrish tells you, was working, and yet when questioned about how he came up with the initial intermittent explosive disorder, there were no facts that really supported that diagnosis. DSM-5 may not be the Bible, but it does have some criteria that experts should look at to see if you can really describe a behavior. There was no prior violence. No one in this courtroom has said the defendant has been violent to anyone other than Andrea. No one has said that the defendant did more than throw a screwdriver, a clipboard, push or throw a mouse from a keyboard down and push a keyboard in terms of the extent of his violence. He's not breaking things, he's not hitting people, he's not destroying things. There is no evidence to support the intermittent explosive disorder. And that's what you heard from Dr. Anderson as well as Dr. Kokler. Now, Dr. Anderson, we agree. He's never been found to be a forensic psychiatrist. He doesn't have that particular credential. What he does have, and what he came in here to tell you, was he has about 30 to 40 years of experience treating patients of all kinds of mental disorder. He had the jury instructions, and while he was maybe not asked the specific question, what was the defendant's diagnosis last June 12th, he knew the purpose for doing the exam was to determine what the defendant's state was last June 12th, to determine if he did have a diminished responsibility, if he had some kind of a mental defect that would have prevented him from making the determination about planning, premeditated, deliberate, etc. So while he was not asked that question, Dr. Anderson certainly had the capability and the experience to make a diagnosis. And it's a diagnosis that apparently has had no treatment since then, so you would expect that if he had that particular diagnosis back on June 12th of 2015, you would have seen some signs of it before and probably some signs of it afterwards. And there is nothing in the record to suggest anything like that. Instead, Dr. Anderson told you he really didn't find anything other than some anti-personality traits. He said he enjoyed talking to him. It was unfortunate about what happened. You heard him describe how he interacted with the defendant, how he got along well with the defendant, he found him intelligent, things like that, and yet he saw no diagnosis of any kind for the defendant. Now, Dr. Kokler is a psychologist, and what Mr. Parrish read to you was out of Dr. Kokler's report when it is describing, or it's the words out of the MCMI-3. And Dr. Kokler, remember, told you had to take this really with some skepticism because he saw an overinflation in symptoms. The defendant was somehow trying to make himself have more symptoms or look worse than he did, which was consistent with what the defendant had done when he took the Sims test, looking at whether he was malingering, and the MMPI. So you have to take what Mr. Parrish read you in terms of what the defendant was like as something to be questioned, possibly, whether it's really real. But in nowhere in that statement either does it say the defendant didn't have an ego. It said he may have an intense fear of being rejected and humiliated, and that would seem to be the case. It would seem like he led a solitary life, although he was married, and that to protect themselves from these fears, they restrict their social environment, constantly maintaining their distance and privacy. Those things may describe the defendant fairly well. What this doesn't do is give him a defense. This is a description, again, of his personality. This is not a diagnosis that says because he scored this way on the MCMI-3, he somehow had some mental defect that prohibited him from premeditating, deliberating, forming the specific intent. And there is no evidence that his score on that particular test said that. Now, there was a lot of statements, too, about how the defendant seemed calm, he looked focused, he had the blank look on his face when people saw him going in to the mall and when they saw him leaving after shooting Andrea. That's because he had his mission. He knew what he was going to do. He was focused. He knew what his mission was when he went there, and he told Special Agent Ron what his mission was. He told others as well. But his mission was to go in there, and it was to completely obliterate the pain that he had. And the way to do that was to kill Andrea. He went in there with that mission, and when he was accomplished it, once he had accomplished it, and then is trying to figure out how to get out and where to go, he told you he doesn't cry. He told Rick Ron that. He was then focused on what to do. Now, Mr. Parrish also brought up he only had $6 with him. Nobody said he had to have a perfect plan about what he was going to do. And if you remember in the interview with Rick Ron, he even said, I should have come up with a diversion. I didn't plan very well. I should have come up with a diversion for the police. Just because he didn't plan everything very well about how he was going to get away and all the things like that doesn't mean he didn't deliberate willfully and with premeditation to decide to kill Andrea Farrington. And he actually did fairly well. He knew to get rid of the gun. He knew to get rid of the phone. He knew to get rid of his wallet. He took off and changed his clothes. He was doing things to be able to change and not be able to be followed so he could get away. I want to go back a little bit then to the civilians. The civilians described the defendant with focus. He knew what he was going to do. He knew what his mission was. He accomplished his mission. And he said as much to Special Agent Ron. If you look at the experts, though, with the exception of Dr. Logan, who comes up with this intermittent explosive disorder that he came up with back in October, Nothing supported it at the time. The state contends that the only incident he can point to of violence is this incident, and it still does not fit. But even if it does, you heard the testimony from Dr. Kokler and Dr. Anderson that this diagnosis is not one that prevents him from planning. And even Dr. Logan, back when he made this initial preliminary diagnosis, included in his report that the defendant could plan. He could make decisions. He could decide what he wanted to do, and that's what the defendant did. So even if you believe he had intermittent explosive disorder and borderline personality disorder, those are not defenses to this crime. Those are not mental defects that prevent somebody from planning, deliberating, premeditating, and having the specific intent to kill. I encourage you to read the text yourself. They're in evidence, all of them, like I said, redacted and not redacted. And one of the things that Mr. Parrish brought up is about their relationship, and he said, quoted as one as, "How was my love?" How Andrea responded back, "Fine, my love," something like that. Read all of the text, please, because there was actually a few intervening texts in there where she writes back something like, "I don't know, how is your love?" like referring to his wife, and then he clarifies he's talking about Andrea. So make sure you actually read those texts and don't accept just as the attorneys have said what they were. Now, Mr. Parrish also talked about this relationship and how it was back and forth, and somehow putting the blame for what happened on Andrea Farrington. I would ask you to dismiss this. Andrea Farrington getting shot on June 12th was not her fault. It was not something she did. It was not something she asked for. It is not her fault. But Mr. Parrish would put it on her by saying they were back and forth, puts it all on her, and it went back and forth in this relationship until he snapped. Snapped is not a defense. Snapped means he became very angry, and that's about when he texted his friend Jessica German, who, while he only met once, had also the same kind of texting or app relationship where they contacted each other many, many, many times, and he told her how he was feeling about getting his Glock and shooting that bitch. That's not a defense. Calling it snapping is not a diagnosis. It is not a mental defect that explains his behavior. When you read the other texts, again, Mr. Parrish tends to put a lot of weight on some very few texts, such as the one to Wendy. The one to Wendy was, it'll be Saturday, something like that. We don't know if Andrea and Wendy had talked about when she was moving. It's not clear what that text means. And I ask you again, look at the text and decide for yourself. But what are not issues in this case? What are not defenses in this case? All of the other text messages that we don't see because they were months ago, and even the defendant's witness from U.S. Cellular told you they only saved text messages for 3 to 5 days or something like that. We were lucky to get them from the 8th through the 13th when they were requested of June. The numbers of text messages, though, don't really matter. The messages between Andrea and other people are not really an issue in this case. Whether you like everything Andrea chose to do is also not an issue in this case. It's another kind of red herring. You may not like the sexual contact of the text. You have every right not to like that if you don't want to. You may not like the fact that she was texting the defendant when he was married or she was in another relationship. You may not like that the defendant was texting Andrea things of a sexual nature when he was married as well. Those are not issues that are going to decide this case. Also, the defendant having migraines and not a lot of sleep, not one expert has told you that that contributed to the defendant's behavior. Not Dr. Logan, not Dr. Kokler, not Dr. Anderson, none of them. That is a red herring that has no basis in making your decision. If there was something there, there could have been witnesses called, and all it is something that the defendant said in one of his statements to one of the people. Now, I want you to know, if I am misstating the facts and I am not saying them correctly, please remember them as you heard them, look at your notes, compare them with everybody else, and I apologize if I have misstated. But I would also ask you to do the same thing if Mr. Parrish has misstated something and you recall it differently, or your notes and everybody else's agree that it was something different than what was said. The other thing that's not an issue, as I said, is the defendant, whether he was going to lose her job. Andrea didn't try to interfere. And even if he was going to have this discussion with Mr. Insissime, there's other things to do if this is going on other than shooting Andrea. He could have broken off the relationship. He could have told Mr. Insissime that wait a second, we're texting each other, let me talk to her, or could you talk to Miss Farrington about whether I really need to stay away? There was a lot of other things. Finally, let's talk about the psychiatrist versus the psychologist. You're right, Dr. Anderson's not a forensic psychiatrist. Dr. Logan has practiced forensic psychology because it doesn't require that certification. He's done this for many years. But really look at Dr. Logan's report. He quickly came up with a preliminary diagnosis, and he decided to stick with that, even if there wasn't much evidence to support it. And Kelly Kozak suddenly coming in saying he's angry a lot, you'll have to judge whether you believe that or not, and whether that fits and would apply to that diagnosis. SNAP does not equal diminished responsibility, and you heard from Dr. Kokler and Dr. Anderson that a personality disorder is not a mental defect that prevents somebody from able to plan, to be able to have goal-directed behavior, make a decision about what they wanted to do. So it's not something that would prevent the defendant from premeditating, acting willfully, and deliberating. What the defendant did, and I ask you to look at all of the evidence, as Mr. Parrish did, we do want you to use your common sense. Use your common sense. Think about all of the testimony you had, what the defendant did, what the defendant said, and what makes sense. He went to a mall that day. After texting his friend Jessica German about what he planned to do, he had plenty of time between when Deanna Brown saw him so angry and when he came back to the mall to cool down, do something else. And he didn't even tell Deanna Brown that he was mad at Andrea. He could control that part of himself. He could control what message he was giving to Deanna Brown. He never said, I can't stand Andrea anymore. He just complained about Cy and Sisame. He was able to control things very well. He could drive successfully the 3-point-whatever miles to his house. He was able to decide what he needed, including clothes, because he was thinking about not coming back. He was able to text Jessica German, do you want to run away with me, or would you run away with me? He was able to pack the things that he needed. He didn't have other cash there, so he realized later he had to get some more cash because he didn't have much. But he took the things that were important. He took extra ammunition. He took his loaded gun. He made sure he had an extra magazine. He made sure he had his knife collection, his hatchet collection. He got dressed up for the occasion. He changed his clothes into something. And he went and he parked in the place closest to where the Welcome Center is so he could get in and get out. That's why he parked there. If he knew where the surveillance cameras were, he would know there were no surveillance cameras in the food court or by the Welcome Center. And surveillance cameras outside don't show individual faces. Ask yourself, did he have the ability and capability to deliberate, premeditate, and decide with specific intent that he was going to kill Andrea Farrington? And did he relate all of that when he was interviewed by various people, including Special Agent Ron? He did. And what did he do then after talking about this, writing it to Jessica German, going and getting his belongings so he could carry out this goal as he went back to the mall. And he walked in with a focus and a mission. And what he did is he then carried out his mission to eliminate the person who was causing him pain, which was Andrea Farrington. He shot her. He shot her when he was in that cold fury because he was angry. He was angry she was breaking up with him. He was angry that she was going to see somebody else. And that's the reason he did it. Not because of some kind of a mental defect, but because he was angry. The state asks that you look at all of the evidence in this case. I'll review the testimony of the different witnesses, look at the phone records if you want to, and we ask you to come back with the verdict that is right and true in this case, first-degree murder. Thank you.
Ladies and gentlemen, there are 5 forms of verdict. You will use and sign only one of the 5 forms. They are numbered verdict number 1 through 5. When you reach a verdict, you will sign only one of those. When you have reached the verdict and signed the verdict form, you will notify the court attendant. She will then bring you back into the court where we will accept the verdict. Ms. Mergis, would you please come forward? Do you solemnly swear or affirm that you will take and keep this jury together in their jury room unless directed by the court? You will not allow any person to speak to or communicate with them, nor speak with or communicate with them yourself, except to ask whether they have agreed upon their verdict. You will not communicate with them on the state of their deliberation or the verdict agreed upon until after the same shall have been declared by the court, received by the court, or the jury is sooner discharged by the court, and the exhibits taken by you and delivered to the jury will not be left unattended or tampered with until returned into open court. If so, say yes.
Yes.
Ladies and gentlemen, with regard to the exhibits, I am going to send the exhibit that is the disabled firearm back into the courtroom. It is my policy to never send a firearm and live ammunition into the courtroom at the same time. Exhibit 25 is an ammunition case. It is sealed, but it does contain live ammunition. If you wish to see Exhibit 25, you will give Ms. Mergis the firearm and she will bring Exhibit 25 into you. With regard to the videos, you will be given a laptop. In order to watch a video or listen to an audio, all you should need to do is put that disc in the laptop. The laptop will prompt you as to how to play it. At this point, we are going to select 3 of you. You remember jury selection? 3 of you are, in fact, alternates. I assume these are...
There we go. All right.
Okay, Ms. Burgess, I'll have you pull the names and I will read them. Do one at a time here. Ms. Burgess, the original instructions, you will need the copies that you had in the jury box. Please leave those out here. Those will be collected and destroyed.
That is recorded now.
You may. And those of you who are excused, I'll have you step down out of there, otherwise you'll be in front of the door. So ladies and gentlemen, I forgot one wrinkle. For those three of you who are excused jurors, I am prohibiting you from giving any interviews to the press or discussing your jury service on social media until after you know there is a verdict returned in this case. After a verdict has been returned, if you wish to discuss this case on social media or talk to the press, that's your business. You're not obligated to do either of those things. If anyone attempts to talk to you and you do not wish to talk to them, you may politely say no. If anyone persists in talking to you after that point in time, you should contact me through the courthouse, because at that point I would need to be involved. But I would ask that until you know the verdict has been returned, please do not discuss the case with the media or on social media. With that, go ahead.
Tyler, this report is now in recess.
Thank you. Counselor, everybody please be seated. Just want to make sure we have all these. Let's make sure we have the exhibits all in order so we can send them back. So I'll trust Ms. Boogie to do that. I will make sure the forward for you. Here's T2.
Oh, thank you, Judge.
Once the two of you have told me that you have everything